that dealt with intellectual property. But the idea of the proposal was to require that countries, WTO members, implement in their laws a requirement so that anyone who conducts research on genetic resources that leads to a patent, that leads to a patent application, would have to disclose in their patent application the source of the genetic resources, evidence of prior informed consent, evidence of mutually agreed terms for accessing the genetic resources, and evidence of equitable benefit sharing. So it's taking the CBD concepts and it's incorporating them into the patent law. And the consequences of, according to the mainstream proposals that are on the table now, the consequences of noncompliance would be the rejection of the patent application or the potential for a subsequent invalidation of the patent application, of the patent. So severe consequences potentially, and we'll talk a little bit about national implementation of some of these concepts and how they get even more severe later on. So that issue was rolled into the Doha round of multilateral trade negotiations at the WTO, and it's still being discussed there. And later, there was a negotiation for the patent law treaty in the World Intellectual Property Organization, and the delegation of Colombia introduced language into the text that was related to a patent disclosure requirement. So the negotiation was halted because this was not consistent with the aims of the patent law treaty. Was to essentially look at formal requirements for obtaining a patent, like do you need a signed declaration? It's very, very simple formal requirements that didn't have to do with substantive issues like this particular proposal. So the agreement that was reached is that it would be taken up in the appropriate forum in the World Intellectual Property Organization, but it would be removed from the PLT text. So that agreement was carried forward, and the WIPO Intergovernmental Committee on Intellectual Property and Genetic Resources, Traditional Knowledge, and Folklore was created in 2001 to take up this particular issue. So they call it the WIPO IGC, but the IGC has three main focuses. From 2001 to 2009, it discussed genetic resources, traditional knowledge, and folklore. In 2009, it launched into a formal negotiation on those three subject areas. So we have three texts that are being negotiated, and one of them is the genetic resources text, and the genetic resources text is focused on this concept of a new disclosure requirement in the patent law. And I say patent law, but really the proposals that are on the table are to extend it to intellectual property rights more broadly, so it would affect plant breeders' rights, and theoretically designs and somehow maybe trademarks, but I'm not sure how all that would work. So these negotiations are ongoing. In June is the next round of the WIPO IGC negotiation. We will it's going to be a particularly contentious round of discussions, of negotiations, because the biennium, the mandate for the WIPO IGC will expire at the end of this year. So in June, the IGC is to make a recommendation, negotiate a recommendation to the WIPO General Assembly for the future of the committee, and there will be proposals for a diplomatic conference to negotiate a treaty on this particular issue. And the U.S. delegation, among some others, are not convinced that this would be an appropriate outcome at this time, that a new disclosure requirement, especially one linked to the consequences of denial of intellectual property rights or revocation of intellectual property rights, would be appropriate. So that's where we are. Very important set of issues. Hot topic. Our two IP attachés in Geneva are working closely together with people in headquarters on those negotiations. So then let's talk very briefly about national implementation. So these concepts are there internationally in the WTO and in the World Intellectual Property Organization. Some WTO member countries and some UN member countries have started to implement them into their national laws. India is one. They had in 2003, the National Biodiversity Act went into force. In 2005, a new disclosure requirement was placed into the patent law. The disclosure requirement, as I've explained before, it would include a requirement to disclose the source of any genetic resources used in making an invention. The consequences are, and it's linked to prior informed consent, mutually agreed terms, and access and benefit sharing. The consequence of noncompliance is rejection of the patent application or invalidation of the patent. This interfaces, not only in India, but in other countries like Brazil, it interfaces with the access and benefit sharing laws, so that once you've made your disclosure through your patent application, then you're subject to penalties under the access and benefit sharing laws. So the National Biodiversity Act, which is administered by the National Biodiversity Authority, requires permission from the authority for any access to the genetic resource, for any use or research on the genetic resource, for any transfer of the genetic resource out of the country, collaborations with foreigners. The list goes on in terms of the things that you need permission from the National Biodiversity Authority to do with that genetic resource. Several years ago, when I spoke with the Council of Scientific and Industrial Research in India about this act, they hadn't been able to reach an agreement, hadn't been able to get permission from the National Biodiversity Authority to have any collaborations with foreigners, foreign institutions on genetic resources, because the benefits that were being demanded from the National Biodiversity Authority were just too high. And that's another provision that I should mention in the Act, is the National Biodiversity Authority determines the amount of benefits to be shared, and they can set whatever amount they think is appropriate. So from what I understand, it's been extremely difficult for anyone to get permission from the authority because the benefits are just not realistic at this point in time. Brazil took a similar approach. They had first of all, a lot of non-compliance, and then they began to prosecute. Well, I should mention with India, so in addition to, if you don't comply, you can be fined by the National Biodiversity Authority. You can also be imprisoned. So you've got the invalidity of your intellectual property right and the potential for significant fines or imprisonment. Brazil had a very similar law. There was a lot of non-compliance. The Brazilian authorities began to prosecute Brazilian companies and multinationals, and the Brazilian companies began to lobby the Brazilian government to say, look, this isn't working. We have been fined millions of dollars for not complying with the system that's very complicated, and we're risking the penalties of going to prison. So ultimately, the law was revised, and this was probably 2 years ago, to make it much less onerous. So now it doesn't affect validity of the intellectual property right or the patent right, but there's still a royalty that's demanded, a payment, and it's not a perfect system, but it's improved. But there is a patchwork kind of emerging of some national implementation along these lines. India, I would say, is among the most far-reaching of these sets of national laws, and this is something that we're concerned about. We think that the concept of access and benefit sharing is valid. We think it can be achieved through contractual mechanisms, and that it doesn't need to be done through the intellectual property system. We think that our overarching concern is that if you attach a disclosure requirement with penalties of denying an intellectual property right or invalidating an intellectual property right to the intellectual property system, it devalues the intellectual property right. People would be concerned about investing in that right if they thought it might be invalidated subsequently, so they'd be less likely to invest in the technology. So it would become a disincentive for innovation, or it would at least reduce the current incentives that are there for innovation. So it's something that's on our minds, and it's something that we care about. There are lots of other questions that arise in relation to a new disclosure requirement. One is if you're tracing the legal provenance of a genetic resource, how far back do you have to go, and how far back can you go, and also who would receive benefits. Would it be the originating country? Would it be all the countries where the genetic resources has resided until it's reached the final point? We saw a presentation this morning where somebody mentioned a species that was introduced into South Africa in the 1600s. So are we talking about going back to the original country where that came from and paying benefits to that government? It gets very complicated when you start to think about all the questions that surround the integration of the concept of access and benefit sharing into the intellectual property system. And again, this is something that concerns us that we're looking at, and I think it might be relevant to you all. Thank you.
Questions? Comments? If not, I've got three things. One of them, with these potential disclosure requirements, has there been any, whether we have any statistics, but where people are declaring the parental lines used in crosses, do you think it will force more people to not declare commercial varieties that might be used and to switch it to internal code numbers to not have to deal with getting permissions?
Well, I'm not sure if you would be able to escape liability under something like the Indian National Biodiversity Act if you said that you didn't have an internal system of controls for determining the source of your genetic resources. I think to the contrary, I think many businesses would be worried about the collections that they have now that don't have documentation that would lead them back to the original source. And I've talked to at least one pharmaceutical company that said it has a huge library that was collected pre-CBD, and the huge genetic library, and it was worried that if it was subject to these types of disclosure requirements that it would not be able to comply because it just wouldn't know what the source of these materials would be.
Edgar?
Thank you. Dominic, I just want to raise your attention to the fact that it is not only patents which are impacted by this, but also plant variety rights. And we see in many legislations, especially from developing and newly industrialized countries, that there's a link, they try to establish a link between mud and pig with granting protection for plant varieties. We have the opinion that this is against the UPOF Convention because there are only distinctness, uniformity, stability, novelty, and denomination, which are the requirements and not mutually agreed terms and this stuff. So I would like to raise your awareness and when you send out your people to India, that this is on their radar too. Thank you.
Absolutely, that's a good point. And in the WIPO IGC discussions, negotiations, that's always an issue of whether the text says intellectual property rights or whether it says patent rights. And we, even though we disagree with the concept of creating this new disclosure requirement, we try to keep the language, the U.S. delegation tries to keep the language confined to patent rights, so at least it would minimize the damage to the PVP system, but it's a constant struggle, and we know that there is national implementation that does go beyond patent rights also. Thank you.
Dominic, we in the States often go, or we've started to go to our U.S. trade representatives to raise issues in about various territories and nations whose intellectual property rights laws are deficient or in some cases non-existent for our products. Would you recommend we find a way to talk to your department as well?
I think that would be a great approach if you should meet with the director of USPTO, Andre Yanku, to raise the issue with him. But I would definitely recommend when you're speaking with U.S. Trade Representative's office to also highlight the issue with USTR. I think it's also an issue that would be helpful to raise with other governments that are in the room so they can also appreciate this challenging set of issues. It seems that, unfortunately, in Geneva, there are very few countries that are really objecting to this approach. So I think to the extent that we can help other governments to understand that this would not, if we can help them to understand the problems that this proposal of new disclosure requirements might pose to you all as plant breeders, I think that would be very helpful to the process.
And my question wasn't just based on biodiversity and Nagoya Protocol issues, but just in general, the issues of deficient IP laws around the world.
Yes, and USPTO does care about sufficient IP laws around the world, just like the U.S. Trade Representative's Office. So, yes, I would encourage that you stop in and talk to USPTO's leadership as well.
Thank you.
Thank you.
Other questions? Got one more. It just has to do with some experience we had years ago stopping shipments of flowers out of South America in Miami, and the difficulties of the complications with U.S. Customs of defending or enforcing our rights to be able to just act, in this case, on trademarks. We had to hire detectives in Ecuador that followed trucks and try to find a way to find airway bills and everything else. What is the cooperation between USPTO and U.S. Customs on these issues?
So USPTO is focused on not on the U.S. Customs import side, but we're working, at least the IP Attaché program is looking at how we can help foreign countries to put in place a customs recordation system, other means of preventing counterfeit and pirated goods from entering or infringing goods from entering borders. And sometimes this relates to training programs and targeting and risk management, where we're training customs officials how to recognize what the infringing product might look like. And sometimes it's training about just simply about the identification of counterfeit goods. But and with targeting and risk management, sometimes it's one of the challenges that customs officials face is that there might be a large container full of pillows and television sets and many other things, and then somewhere in the container are infringing goods, and they have to be able to identify, sometimes by looking at the invoice, what looks wrong and how to know which container to actually go into, because they can't go into them all. Mm-hmm. And they're simply overwhelmed with the volume of containers that are coming in. So that can be a valuable tool. But we do have cooperation, our IP attachés have cooperation with customs officials in the locations where the attachés are based. And we're always looking to help them to improve their identification of infringing goods and to prioritize their searching to find these goods, and also sometimes to put in place recordation systems. And we rely on our partners at U.S. Customs and Border Protection and sometimes Immigration and Customs Enforcement, or ICE, to help out with those types of programs.
Thank you. Anything else? Thank you, Dominic.
Sure.